8. Sound. Committee Room 8.
Order. Welcome to our second evidence session. We're starting about a minute early because we've got some rather difficult time constraints today. And for the benefit of the public in particular, we have had to cancel our second evidence session. It is likely that possibly from 2:30 onwards, hopefully slightly later if we're lucky, there'll be a series of votes in the Commons. Sorry, did I say from 3:30 onwards? A series of votes in the Commons. That would cause disruption of 15-minute intervals, maybe on 4 occasions, 5 occasions, up to 8 occasions. It would make a mockery of trying to hold the second evidence session. We'll also crack on briskly as we possibly can with the first evidence session. And welcome Mr Davis, Member of Parliament, Mr Pickles, Mr Killock and Dr Hosein. Perhaps if we begin with each of you just saying who you are for the record. Mr Davis.
David Davis, Government Backbencher.
Thank you.
Nick Pickles, Director of Big Brother Watch.
Jim Killock, the Executive Director of the Open Rights Group.
Gus Hosein, Executive Director of Privacy International.
Excellent. Thank you very much. Gentlemen, could you each start by outlining briefly your main concerns about the proposals embodied in the draft Communications Data Bill? What are the areas which you think, which you each hope that this joint committee will consider? And who are the main witnesses you think we should hear from after yourselves? Mr Davis.
Well, can I start slightly backwards, Mr Chairman, Lord Chairman, by saying I start from the position that the RIPA arrangements we currently have, before we put this new procedure in place, are too lax. When they were put in, I think in 2000, the arrangement they replaced was a combination of voluntary and warranted arrangements, which I think were much safer than we currently have. And in essence, what I see as the current problems of the RIPA arrangements on communications data are the similar ones that we reflected in the current proposals. I think a warranty arrangement would be a generally good idea on both sets of legislation. Helped, of course, with some accelerated procedures, which we can talk about as you go through questions, no doubt. I have concerns about the security of the retentions that are now being required under the new law, and I think that will create a huge security problem, not with the government, but for individuals and the private sector. I have some concerns too bluntly about the quality of evidence put up by the government, because we are in essence dealing with agencies that are relatively confidential in their operations. It's very, very difficult to get down to how effective their current operations are and the extent to which they're simply using our blindness to extend their capabilities. And I can give you examples of that by parallel with other bits of legislation if you wish. I have some concerns about the technical competence of the proposals being brought up, but I think other members of the panel will give some views on that. In terms of where to look, there are some very, very obvious things which will come out. I'm not going to give you a long list, but there's one which strikes me as being unusual, which might be worth looking at, and it's this. The German state recently struck down the parallel arrangements for our RIPA operations, which again I say are like a metaphor for this. And as such, we can see how effective policing and security operations were in that state when they had a RIPA arrangement and when they didn't have it thereafter. I actually think the policing improved across that. And in terms of witnesses, there was a German member of Parliament called Matle Spitz, M-A-T-L-E Spitz, who asked about the information kept on himself. And I think what he found will be very interesting to you, but just as a possible witness. The other thing I would look at, if I were in the committee's shoes, is not just the direct impact of this, but international agreements that apply to it. What data will be collected under these arrangements, which will be available to other states under our existing agreements, particularly European, but others as well. And I think you'll find they're pretty intrusive.
Okay. Thank you very much. Mr. Pickles.
I think I start in a similar position. This has been presented on the premise that it is maintaining an existing capability. And I think the committee should look very closely at the validity and the honesty of that statement, because we are going from an environment of fixed communications where people had a landline phone but did not carry mobiles, where the internet was not pervasive, and accordingly the colour of data available was very different. And so I think it was actually made in evidence in 2009. This is a far more colourful capability that allows the state to look into far more detail of your life than was ever possible, whether that's the websites you visit. We were never previously required to declare the newspapers we read, but that will now be possible under this. So the actual credibility of saying this is not a new capability, I think, should be looked at. And that this is unparalleled on an international scale. Find another democratic state that wants to record this level of detail. And indeed, I think, as one witness, I do hope will be able to give evidence is the Foreign Secretary, because it does appear that this is at odds with a substantial proportion of what is currently British foreign policy. If you listen to the remarks of the Foreign Secretary in the Cyber Conference in November, he talks about privacy as being an essential part of the internet. And the Vice President of the United States went on to say, where countries did pursue monitoring arrangements, that would likely lead to businesses moving abroad to avoid those monitoring arrangements. So I do hope that's looked at in terms of a serious issue for British reputation. I share David Davis's concern that the evidence we've heard so far has been scant, and indeed, if you consider that this proposal has been formulated for several years now, that the last consultation was in 2009, there are currently 120 members of staff working on this directive in the Home Office, and the number of times this committee was told yesterday, we're working on getting the data, we don't have the information, was quite surprising. And I hope that the evidence of effectiveness is brought to bear. I think the filtering provisions, again, as we heard yesterday, do warrant extremely close scrutiny. It's quite disingenuous indeed to suggest that this is not a central database merely because there are lots of little databases. If you connect all the little databases together, you have by proxy a central database. And one of the concerns I have is that the filtering provisions open the door for fishing trips to find out who was in a certain area, things that are not currently possible, again, a new capability. I think, finally, one essential part of this inquiry should be the police forces of England and Wales, who are currently struggling to deal with the laptops and the phones that they currently recover in existing crime scenes. And this resource will divert from their capability to deal with evidence they're already gathering. So making sure the police are not unduly penalised, and I'm sure colleagues will have more points to make on that.
Thank you very much. Mr. Killock.
Thank you. So, picking up on Nick's point about observations back in 2009, the EU Council of Ministers talked about a tsunami of data hitting the police and welcomed that opportunity, commenting that every object that individuals use, every transaction they make, and almost everywhere they go will create a digital record. This will generate a huge wealth of information for public security organisations and create opportunities for more effective and productive public security efforts. Now, that's the words of the European Council looking at the pattern of data that is emerging in the digital age. And I think that's where the focus of this legislation should be. It should be looking at the amount of data that is going to be available to the police and law enforcement in the future as a result of the digital tracks that we create, and how that is then regulated, how access to that is regulated. And I think that presents a hugely different picture from the one presented by Charles Farr yesterday of a declining availability of data. The fact is that data is proliferating, and it will be we'll get about, I think it's about 1,000 times more data available over the next decade, just because of the increases in capacity for storing data through digital technology. On the question of communications data itself, the sort of data sets that Charles Farr believes are becoming inaccessible, despite the fact that those are probably proliferating in terms of communications events that are recorded, I think it is worth investigating the potential routes that are currently available to actually gain access to that data. So there are legal routes within this country, there are legal routes abroad, in European or America or other countries where we have cooperative agreements between the police here and abroad. There are possibilities of intercepting that data within the UK. We have intercept capabilities across ISPs. And we also have the possibility of seizure of devices. You know, if a device has recorded the communications events that an individual suspect has engaged in, then those devices can be seized and they can be examined. So the number of cases where communications data may not be available, it seems to me, are likely to actually be rather small. And I think it's a good piece of work for this committee to engage in to try to ascertain that. Another piece of work the committee should be looking at are just exactly what is the current position with retained data in European law. The Data Retention Directive has been challenged in a number of European states successfully. In those states, it has been declared unconstitutional in a number of countries. Currently, as David Davis mentioned, is not in operation in Germany for this reason. And the committee should try to ascertain whether it is actually compatible with the European Convention on Human Rights. A little bit more broadly, we should think about the change that is being suggested in this bill. We've moved from a question of police access to communications data, which was a traditional position with telephone records, to retention under the Data Retention Directive. That's to say, you keep it for longer under obligations in law, to a question of collection of data. And that is a fundamental shift in approach, and that really does deserve a wider debate, as does the question of data mining, which may flow from creating the ability to query these databases or data sets mentioned in the filtering arrangements. What are the implications of data mining? What sort of information might emerge from that? What are the security and costs that come, implications that flow from this entire arrangement? Moving on to a question of witnesses, I would just start off by asking, where has the consultation process been? I think the committee should establish exactly what the consultation arrangements for this bill have been. I think all of us as witnesses are struggling because we don't actually have a proposal. We don't have a set of evidence that says why this must take place. We don't have a firm proposal outlining how this is going to operate. What we have is the legislation, which should come after both the evidence and the proposal, to allow the government to take on the duties that it's identified it must take on.
Can I hold you there, Mr. Killock? I'm conscious you're in full flow, but we're in a very tight time scale.
Of course. So last couple of points. Look at the Article 29 Working Group. I think they've been looking at data retention very closely. Perhaps invite Digital Rights Ireland, who have experienced abuses of retained data in Ireland, and bring in cases on human rights grounds to the European Court of Justice. Involve overseas communication service providers, because they have a very different view of the legal compulsion surrounding them to the one presented by the Home Office yesterday.
Okay, thank you. Dr. Hosein.
I'll restrict myself to 2 points because my colleagues have done such a great job already. One quick preface. As an academic and as an advocate, I have followed communication surveillance in this country since 1997. I've been here for all the key debates about encryption. I've been here when the debates took place on RIPA, on Anti-Terrorism Crime and Security Act. I was at the European Parliament when data retention went through, and I've been following this specific policy since 2006, 2007. So having said that, my first concern is I still have no idea what this policy calls for. Until we see the draft orders, we have no idea what is going to be asked of organizations. We have no idea what a third-party provider, say, in California is going to be ordered to do. We don't know what the nature of the black boxes, if there are black boxes, how they're going to be implemented at providers in this country, which black boxes, what are they actually going to collect. And I don't know when that debate actually takes place. So it's kind of hard for me to identify problems with the bill when I'm still not entirely sure what the policy is. The second component, as much as I've been able to identify the issues involved, is the sea change around collection. That is, the settlement at a technological, economic, and just at a political level over the past 15 years, if not the past 35 years, has been telephone companies collect this information for their business purposes. It exists within logs. Once that information exists within logs, it can be accessed. It can be accessed lawfully by organizations. That's never been contested. The quality of the access has always been contested, but that's fine. Over the past 15 years, through debates at Parliament about communication surveillance, it's always been about regulating access. Now what's being introduced is the notion of collection. Organizations that have no business purpose to collect information are going to be asked to collect this information solely for the purpose of some future potential access, because one of their many consumers may be relevant to an investigation down the road. And that's the reason why this policy has never been taken up in a democratic country. That sea change of requiring collection for where there is no business purpose originally.
Thank you very much. Thank you, gentlemen. That's very helpful. Lord Jones.
Lord Chairman, gentlemen, the question is, at the moment, the present law relating to the retention and acquisition of communications data, and we would like, please, to hear your views. Does it broadly achieve the correct balance between the need for law enforcement and national security, big priority, to access communications data, and then an individual's right to privacy? And we'd like to hear your views about where the balance should be. The individual has rights. It's all about liberty and privacy. And then the need for our nation to be secure and not to be the victim of terrorism. What is your view? Where do you see, what should be the balance?
Can I keep off? I mean, the first thing to say, sort of reiterate something that's already been said, and that is, we are rather hard up for some aspects of information on this. We don't know how many things have been turned down, how successful each individual request is, and so on. But these just sheer numbers, we've got 550,000 or so access requests a year. It seems an awful lot of data. We can come back to what it really means in a minute. The accelerated access requests, just talking 2010 data, is 31,000, up from 21,000 the year before. Now, I can't think that there were 50% more kidnaps or 50% more terrorist events, the sorts of things that ought to perhaps precipitate an accelerated request. So my hunch, and I can't put it stronger than that, is that what is happening is the agencies are quite understandably using every power they've got without any thought of restraint. And I suspect we'll find that when we investigate this, if we can, a great deal of that information is wasted, a great deal is unnecessary, and as a result, it's an unnecessary intrusion on individuals' privacy.
Anyone else?
I think we haven't got the evidence. We know there are more than 550,000 requests. Is there any evidence offered to how many of those are terrorism related? We're told the information is in progress. Well, I mean, it's remarkable that I managed to get through Freedom of Information law, more information than the Home Office team yesterday seemed to have. But one police force did give us a breakdown of why they were using communications data by offence type, which I know was something that was discussed yesterday. And traffic offences is on there. Terrorism is not. South Yorkshire Police, sorry, I apologise, Humberside Police.
My police force.
Confirmed that they have used it more than nearly 200 times in 3 years for traffic offences. And terrorism is not listed as one of the crimes. They even beautifully list the category other non-crime. And I'm happy to make this information available to the committee. So let's look at the numbers. In Germany, they did. They went through and they looked at when this was being debated, and the German Federal Criminal Police Office looked at 381 cases where communications data was cited as critical, and of those 381 cases, 2 had a link to terrorism. Now, I want to see the Home Office bring forward the same evidence. Is why are we sat here discussing this, saying there are lots of terrorist cases, but we don't know how many? Well, it must be very difficult to manage your investigations if you don't know how many investigations you're currently running. I think that the position has been presented from the start of we need this information, and when we ask why, we're told we can't tell you. And for the unprecedented scope of these proposals, I'm sorry, but that is not good enough, because this is bringing to life the fact that every British citizen now carries in their phone a tracking device and makes that information available. And that's unprecedented and is not currently the case under existing law.
Very much. Not every colleague needs to intervene unless you particularly want to. I'm conscious of the time scale. Could I, Mr. Wright, could I perhaps? Oh, no, sorry, Dr. Hosein.
If I may just take a structural approach to the question you've asked. It isn't for us to say yes or no to your question. It's more interesting to ask the question as to who is the one who decides on a case-by-case scenario. Parliament should decide about where that balance is struck. But what we've seen is for the past 12 years, Parliament's been relatively unhappy with RIPA, but very few fixes have come along in a 12-year period. Should we leave it to the judiciary? Well, the judiciary is not involved, unlike in other countries where there's usually a court order involved in deciding whether access to the data on a case-by-case basis is relevant. Is there some independent regulator, as there is in some countries? No, there is not. So who has to make that balance calculation? It's the police. That is not the way that it's done in democratic societies. That is not how it's done in accordance with Article 8. You need to come up with a system for deciding on a case-by-case basis what is necessary, what is appropriate, what is proportionate. And right now, asking us the question, it's an interesting debate for us to be having, but I think 12 years into RIPA, we should be asking on a case-by-case basis, where should that question be asked and who should be answering it?
Thank you very much.
Sorry, one brief point to that, which was again on the figures. To use one example of Kent Police, in 2 years they made 7,664 requests for communications data. Within the police force itself, they ruled that more than 3,000 were inappropriate. So there are a lot of police officers making mistakes about the proportionality of using this capability.
I think we'd like to see that data.
We're currently working through about half the police forces, but more than happy to share
when it's complete.
There's only 3 staff and people to watch, unfortunately.
Could I go, Mr. Wright?
Killock, your line earlier was that there is significant data proliferation. I think all of you would accept that. Charles Farr and his team, the other members of the Home Office team yesterday, were talking to us about this gap, about the fact they wanted to put in legislation that would bridge their capability gap to draw them up to, I think it was 85% of accessibility. You've made a good series of introductory points, but my concern is there is going to be this gap, and we can argue about thousands of bits of data, but what about the 2 that do sneak through, that we could have identified, that do relate to terrorism? So what we've got to do as a committee looking at this bill is get the balance right between exploring the data gap that we're being told about and making sure it's targeted properly. Do you accept there is this gap and that we do need to make it up?
Can I draw your attention, it's an oblique answer, but I can draw your attention to the 7/7 bombings. We missed them. Did we miss them because we didn't have data on them? No, we didn't. We missed them because we had 2,000 plus targets and we misclassified them. This is not the only example of the agencies screwing up, not to put too fine a point on it, because they've got a large amount of data they don't know how to manage. You could even, if you have them in private session, ask them about the effectiveness of their data management systems. I could tell you they had to use the Cabinet Office's data management system at one point. So you've got 2 problems here. One, you've got the availability of the data, the other is the manageability of the data. And do you actually improve the effectiveness of your crime fighting by gathering data on 40 million innocent people?
Well, the point the Home Office is making, Dave, is that yes, you do. I mean, that's clearly the pitch that we were being given yesterday.
Yeah, but the evidence is
that yes, it does.
But the evidence is the other way. Okay. And you need to talk to them about actual operations to show how many times they make mistakes which arise directly out of misclassification of data. They're looking for the famous line has been used. They're looking for a pin, and they're creating a field full of haystacks.
Sorry, we need to take that.
Sorry,
yes. Any other witness?
Just a little bit of information there. I mean, David Davis mentioned what had happened in Germany. In both Germany and Czechoslovakia, when they stopped having access to communications data under data retention, their rates of solving crime went up. So in the Czech Republic, they had a tenfold drop in requests for data because data retention was ruled unconstitutional. But the rate of solving crime went up from 37.5% to 38.5%. So that doesn't really say that this data is always or even largely critical for law enforcement. And I think what you probably need to do, if you really want an answer to your question, is to drill down very, very carefully in the cases that they are presenting to you where they have used communications data. And you have to really forensically ask in each case, was that critical to solving the crime, or would they or could they have found the same individuals through other parts of data or other parts of the investigation? Generally, I think communications data can be useful, but is probably not always critical. But that's something that you need to investigate, I would suggest.
Okay. Any other colleague on this point before I move to Mr. Ellis? Dr. Hubbard, and then...
Thank you, Lord Chairman. And before I do, if I could just declare an interest as a member of the Advisory Council of the Open Rights Group. So, you've all been quite clear, I think, that there is a lack of clarity about what is being requested. And presumably there are two issues. One is what the Home Office currently plans to do with an order. And I presume you've spoken to them and asked them what that is. There's also an issue about what the limits of the powers given by legislation for future orders are. Have you got any clarity from them or from talking to CSPs about what the issues are with those two? Is it acceptable either as the order they intend or as the order that could come later?
It's very difficult to speak about examples because, there isn't an order out there to even point to. But let's use one example that we have heard of, which is an order will be placed against Google. Google will be required to collect more data on UK users, to then retain the data on UK users, and to disclose data on UK users. The challenge that arises is first, a lot of these providers don't actually know what a UK user is. There may not actually be a field saying, yes, I'm from the United Kingdom, I have an account. This often happens in Skype. You don't actually say what your country of origin is. And then we're actually paying these companies to collect information on users. These companies are expert at making a great deal of money off the collection of information on users. We tend to fight at a regulatory level to ensure data minimization amongst these companies. But here, not only are we asking them to collect more information, but we're actually willing to use British taxpayer money to pay for them to collect more information. But that's what this policy would entail, at least when it comes to these third parties. For an ISP in this country, we presume it involves in order to require them to install a certain type of technology according to a certain type of spec, of which they may pick one or two options and put them in and ask no questions. Now, of course, there's a technical advisory board that may meet to question whether this is the most appropriate technology. But once that technology is in those ISPs, do they have control over that technology? Can they decide what that technology does or does not do? Can they decide when that technology gets updated and what it then grabs? They probably cannot.
Okay, thank you very much. Mr. Ellis.
Thank you, Lord Chairman. I'd like to just try and pinpoint the issues down a little, if I may, gentlemen, and don't all feel the need to answer each question individually. But many of you have criticised the draft bill on the issue of authorisation, by which I mean it doesn't require the draft bill public authorities other than local authorities to seek any independent authorisation to obtain communications data, by which I mean a magistrate or judge or any other type of independent authorisation. So at the moment the bill envisages a senior designated officer from whichever public authority is relevant, I think a superintendent, for example, in the police, or the equivalent, to authorise requests. So do you think that independent authorisation should be required for every request? If so, would that be practical? We've heard evidence already that there's over 500,000 requests last year. Or would you find that somewhat expensive and time-consuming if you had to seek a magistrate's authorisation 500,000 times a year?
Shall I start? Firstly, the reason it's 500,000 times plus is because you haven't got a proper checking procedure. That's the first thing. Second thing is, if you raise the 550,000 in another context, people rush to tell you, Mr. Farr and the ministers rush to tell you, this is not 550,000 people. Indeed, in one criminal case, it could be 1,000. You know.
They have already said that.
They've already said that. Of course they have, which has implications for the warrantry process. They say, for example, if you were murdered, heaven forfend, they would look at your phone record and then look at who's involved. And let's use phones because it's easy and it's in place already. And then they check on every single one of those. That's actually one warrant. That's not a whole series of warrants. And so you're not talking about 550,000 warrants, just as you're not talking about 550,000 people. The issue which is material here, however, is speed in the individual case. There are circumstances, and again I'm going to stick with phones, but it's applicable elsewhere, particularly with kidnaps, where location data is used. If I kidnapped Mr. Pickles here, and it was an active kidnap, the phone...
There's a need to move quickly.
Need to move quickly. Now, under circumstances like that, I'm perfectly happy with a very accelerated or even retrospective procedure, although quite a tight one. You know. But they're small numbers. They ought to be small numbers. As for the rest, frankly, there ought to be a deterrent not to use it frivolously. And so in that respect, I completely turn over the argument you put.
I think sorry,
if I may bring up the international angle on this, the United Kingdom stands relatively alone in the democratic world for access under this type of regime. Let's use the United States as an example, because the United States is often picked on for its lax regime. Outside of the field of national security, when it comes to access to communications data, it requires a court order. Not only does it require a court order, it also requires, by default, notification to the individual that after the investigation is complete, that their data has been accessed. This is in the United States.
Yeah. It's expensive, isn't it, though, Dr. Hosein, to go through a court order on every occasion?
I think the Americans see it differently when they say it's according to their constitution.
Right. So none of you would be concerned about the expense to the public purse of having to go through lawyers and courts every time the police or...
I think the other question about the 500,000 requests is that most of them are probably for subscriber data, which is a relatively routine matter. And it would be really, really helpful if the Home Office would make some sort of disclosure around how many of these 500,000 are simply for whose phone is it.
Well, I was going to ask you about that, actually, Mr. Killock, because there are types of data, and you allude to subscriber data, which is simply the data to acknowledge the name of the person who has the subscription. So it isn't as sensitive, most would argue, as some other types of data. Would you be more relaxed about that being obtainable without a warrant or without?
Slice through the middle of it. I have no need in my mind to have a warrant to effectively operate a directory inquiries, which is what this amounts to, giving name and address and some basic details, maybe other phone numbers. But I would say you'd still need a warrant for details about your account funding, where the bank account comes from, and that sort of thing.
Are there any public authorities that you would say we don't need to, or you can accept that should not have independent authorisation? Would you say that everyone should have authorisation, police, security services, no exceptions?
I think Gus's point about the American system is absolutely right. If the FBI want to put a GPS tracking device on a car, they have to go to court.
Yeah, I think no exceptions, and two reasons. One is that actually, if you look at this 550,000, the vast majority are policing and security agencies. Once another, the famous ones, the local authorities and so on, who are semi-frivolous, are really quite small numbers. If we're dealing with the issue, the big issue is is law enforcement.
Well, of course, the local authorities now would have to seek independent authorisation. Do you have, any of you, any evidence about individuals who have suffered harm as a result of their communications data being improperly or being accessed by an investigator and harm has been
Not
sustained?
in the critical area, but if you had asked us that question about phone hacking by the newspapers 5 years ago, the answer would be the same.
As long as we are not notified of the fact that your data has been accessed, you can never know that that was the reason why you were harmed.
Is it not right that, for example, the person who has a supermarket club card, the data that's held on that by the company in question, I just use a supermarket as an example, can be in and of itself really quite extensive? And are you not seeking, by the positions that you're taking, to put an extra burden on those who are trying to prevent and solve crime than is actually put on commercial entities in the operation of their affairs? What do you have to say about that?
I think we've spent the past 5 years, if not more, arguing for greater protection for consumers. And one of the main areas that consumers do need more protection from is where they are not aware their data is being taken. And that's a huge problem. But I think the broader point is that this 550,000 figure is a very large number, and nobody's quite established why. And I think that should be deeply concerning. And so my question would be, as we've previously suggested, I know the Home Secretary used an example of a CEOP operation, where you have identified somebody at the centre of something which is criminal. Right now, without any court authorisation, that individual's communications, including content, can be monitored. And so what I think one question to ask would be, to say the police, would be why in that situation would they rather arrest an individual and then rely on communications data than monitor the individual and, including content, see who they are communicating with before they make an arrest?
Could I just put that number in context? 550,000. In the same year, I think the FBI's total number of equivalent comms data requests was 17,000, and the maximum over the course of the previous decade was something of the order of 50,000. Okay. So that puts it in context.
So, on the issue of the warrant system, are you all satisfied that that would actually be any more robust than a senior designated officer who would be specifically trained in the area that he or she would be dealing with, and would be subject, after all, to criminal sanction if they abused their authority in that area? Would you not be concerned that a system that requires a magistrate's authorisation or the like is open to abuse as well?
And that's an excellent question. And that's why in other countries around the world where they already have judicial authorization, they still have complaints as to what is that judge actually assessing. How much information does he or she have to make a decision of whether something's proportionate? How are they able to are they actually able to say no, or is it just they have to do a rubber stamp? These are questions even within countries that have judicial authorization.
To go through on the nod.
Or put better, at least they have judicial authorization as a starting point to then deal with the exact same questions that we're dealing with here.
The reason I've used the phrase "the guy at the next desk," which of course is apocryphal really, was because I was communicated with by one of the staff of one of the commissioners involved at the time of my by-election, who rang me up and said, "Keep going, because you're absolutely right, because this is what goes on. The people have got the same mindset and they don't challenge each other." That was his comment. It wasn't a question of abuse, it was a mindset.
Yes.
And I think that mindset is illustrated by the fact that in 2010 there were 30,000 oral requests which were approved under REPA. So there was never a written down document asking for permission, it was orally approved. Right. I think that illustrates that.
Two final points from me, if I may. Firstly, do you consider that any of this within the bill would be effectively in breach of the Human Rights Act, if I can raise that? Do you think, for example, that Article 8 is an issue here? And also, would you or any of you approve of some sort of halfway house measure whereby there'd be a level of third-party control somewhat short of a full warrant system, but which would have some other mechanism? And how do you think that would work, if any of you are in favour of that?
On Article 8, you're a better judge than me, sir. And on the issue of halfway house, no. But I would look at the question of how big a warrant, what a warrant should cover. That would actually reduce some of the burden involved. And I'd look at the question of accelerated procedures, which will be used very rigorously, but are the area of importance in my view. None of us, I think, want to undermine police effectiveness in this. We're much more worried about that than cost, in truth. And I think that's a way to do it, through the warrant structure and the accelerated procedure.
I think that's a straightforward question of civil society, is that this is the kind of tracking that China and Iran are quite fond of. And does Britain want to be a country that has that amount of information retained about its citizens? Specifically, you can call that human rights, you can call that decency, you can call that liberty. There is a question over judicial remedy, particularly with regard to the fact that I think in 99 of the 210 cases heard by the Surveillance Commissioner to date, they have resulted in no judgment either way, which is remarkable in any court to have nearly half the cases with neither one side or the other winning. I think that's an incredibly broad question as to the halfway house, but I think you've got a fair impression from all of us that the situation we are in today is not good, and we need to be moving backwards from that.
Okay, Baroness Cohen wants to come in on this.
I have one of those fundamental questions that has struck me as new to this lot, that in a way it seems to be a little odd to have a system which picks up first whether a communication is taking place, and then second, the content of that communication. Am I right, Dr. Hosein, in thinking that if you applied for a warrant in the States, you would apply for both, but that the communication was taking place and what it was saying?
I would, based on the cases that have hit the Supreme Court, it tends to be applying for a warrant for the police decide what is actually going to be the most effective measure based on the evidence they have to date. And so if they have enough information and probable cause to believe there's a crime about to occur or a crime has occurred and they need to find out information, they'll get a warrant for interception of communications. But if they do not have enough information to actually convince a judge of that higher burden, then they will apply for access to the communications data.
So it's bespoke?
Yes.
But on the GPS warrant case specifically, that was argued on the point that putting a GPS tracker on someone's car constituted an illegal search of the individual. So there's a slightly different nuance there, but they came to the conclusion that just tracking someone's location constituted a personal search and therefore should be warranted.
Okay, Mr. Brown. Oh, sorry.
Sorry, it's a temptation to think, and I thought the Home Office was almost saying to us that, you know, you can kind of get a huge sweep of information without being that intrusive.
Would that be the filtering of proposals they were discussing?
Yes.
Yes.
If you just go for whether a communication has taken place, you get a huge sweep of information, very useful to you in pinning down your investigation, and not that intrusive on the citizen.
Well, I think.
Go on, yes.
I think what's intrusive is all about context, isn't it? I mean, if I'm emailing Alcoholics Anonymous on a regular basis, that's pretty indicative of what I'm talking to them about. So, you know, similarly, if I'm communicating with a group of individuals on a particular issue through a particular website or something, then that tells a lot about my political opinions and my political organisation and perhaps even my decision to protest at a particular point. Similarly, if a journalist is communicated to by somebody who's on a list of potential leaks, the mere fact of communication pretty much tells you that they're the person you might want to arrest. So traffic data is actually incredibly intrusive, and that's why it's useful. But that's also why it needs to be regulated very, very tightly.
I mentioned earlier matless bits. I was talking about telephones rather than emails there. When the German court struck down the German law, which is the Ripper equivalent, not this equivalent, he obtained from Deutsche Telekom 6 months' data on his own telephone. He thought he'd get a few hundred telephone calls. What he was given was 35,000 data points of where he was for every 5 minutes of his waking life. It's on the web if you want to look. You search on the matless bits. So basically that man had a tracker on him. So this is intrusive in all sorts of ways. I could give you half a dozen other examples, but it may give you a measure.
Yes, I agree.
Sorry, Mr. Brown, I'm conscious we're on a very tight schedule.
We are rapidly moving up against the bell. Look, two points. Firstly, have you anything to say to us about the danger if you advocate a warrant system rather than a senior official authorising a junior one, about the danger of tame magistrates, in other words, people choose which magistrate they're going to go because of their known position on these matters. And secondly, it's been put to us that the reason why public officials dealing with sensitive data don't sell it to newspapers or sell it on to other people who can make commercial use of it is that they would be caught and punished. Are people caught and punished? Is there anything you could say to us on that as a assumption? Does it work?
In your previous life, you must have come across cases where data about members of Parliament was sold by policemen, time and again.
This is the point I'm getting at.
Yeah.
But they don't seem to be caught. They don't seem to be punished. And in the case of the offence of misconduct in public office, there's a ruling by a judge that says that it wasn't committed seriously enough.
So what's the point? Were you driving with this?
Is there anything you want to say to us about the effectiveness of that as a sanction?
No, I think it is an effective sanction. I mean, it'd be quite interesting for you to question the officers who searched Damien Green's office as to what happened when they tried to get a warrant. I think you find that to be quite interesting. But the simple truth is you've got to manage warrantry like you've got to manage anything else. Not allow the same magistrate to be asked every time, or the same judge to be asked every time, and set certain levels of evidence required for the magistrate. It's not simply a handover to somebody else. It's actually a structured process.
Well, I think on the penalties point, I would simply say that I hope the Information Commissioner has been at the heart of the Home Office's discussions about this bill, because he is responsible for an awful lot of regulation, and right now the Information Commissioner can't walk into my local GP surgery without their permission, let alone Vodafone or a commercial services provider. So, and if he does find wrongdoing, breaching Section 55 of the Data Protection Act does not carry a custodial sentence.
Sure.
So I think we've had clear calls from the Justice Committee to say this should happen. I think the Leveson inquiry would have been avoided had that been available and been prosecuted. So, and that's actually on the statute book. It just hasn't been enacted.
Lord Strasburger, you want to come in on this, and then I want to move to Lord Foulkes.
Dr. Hosein, in your opening remarks, you rather threw away a rather stark statement, which was that these sort of measures have not been taken up in any other democracy. Would you care to elaborate on that?
So, thank you. The collection of data through black boxes at ISPs in order to monitor activities within a country and beyond a country have only been implemented at a national scale in China, Iran, and Kazakhstan. Now, the use of DPI, deep packet inspection, and black boxes have been used at a local scale, and we have cases in Egypt, Pakistan, and Tunisia. But the idea of a black box run at a national scale, organized at a centralized level as to what will actually be monitored, has not yet been done in a democratic country.
Thank you. Thank you. Lord Foulkes.
Yes, I'd like to ask you about permitted purposes. The bill lists quite a number of permitted purposes for which communications data can be obtained. I think they're based on RIPA, although there's also a power the Secretary of State may order in addition to the permitted purposes already listed. Are you concerned about the range of permitted purposes? And if so, which particular category is concerned with?
It'd be quicker to say what's not permitted.
Yeah.
I am concerned about preventing disorder, given what we had with the police handling of a number of environmental protesters on that front. Financial services are restricted fine. Economic well-being in the United Kingdom. Interest of public safety over and above detecting crime and terrorism. Public health. You know, I mean, are these serious things? What we've created here is the longest possible shopping list the Home Office could come up with. And you could probably get away with national security, preventing and detecting crime, the financial services stuff, to invest in investigations of alleged miscarriages of justice, and final category, a dead or disabled person. The rest, I think, are OTS.
I do apologise, I forget which member of the committee yesterday asked for the scenario, in fact Mr Chairman, it may have been you, who asked what situation could arise where a single request could affect multiple individuals. And indeed, a reading of the preventing disorder may be that in the case of a protest outside Parliament, you would want to know the identity of every mobile phone within a half mile of Parliament Square, so that there would be a way of identifying people who are on a protest. It's a natural extension of what the Metropolitan Police currently do with their forward intelligence teams, who hold photographs of individuals and has just been ruled unlawful. So I think the scope of this is not just the types of offences, but also the manifestations of the new technology, which could then be applied to, as Mr Davis says, what is an incredibly broad and list which should be cut down under the existing law.
But I suppose you could think of individual cases which might not easily fit into limited categories, hence the expanse, where, given the particular facts, you say it was reasonable to obtain that information. Presumably that's the purpose.
Well, frankly, reports, I would challenge anybody to say, if it's not in the interest of national security, it's not for preventing or detecting crime, it's not under the very specifics of the FSA, or where somebody's injured, or the miscarriage of justice, why is it in the category? Give me an example which fits. There are cases which will be about protecting public health, but they will be a crime almost certainly if it's and ditto public safety. It's very, very hard to think of a real example, and this has created a complete open sesame here.
And this
It's not good law.
This is for the obtaining of communications data, not the disclosure of communications data. So I think that's an important distinction to make.
And traditionally, we've had limitations placed on some investigations. We've said you cannot breach privilege, for instance. RIPA erased all of those previous limitations on the cases and the types of situations where you get access to information. And in some countries, they actually limit the purpose of an investigation. So if it is linked to, as the example was used, political protest, the practice of free expression, or anything having to do with your religion, then you cannot conduct that investigation whatsoever, unless another crime is actually being conducted. It'd be nice to see those types of limitations.
Thank you. Dr. Hubbard, you might get a couple of words in.
Thank you. Very quickly, we've been assuming throughout, or as the Home Office were assuming yesterday, that there was a very clear distinction between communications data and content. How sure are you that those are completely separate? Would the proposals in the bill perhaps lead to content being collected? And in particular, could any black boxes collect content?
I need to stop you there, the division. Ladies and gentlemen, in a moment I will adjourn the committee. There's a start of a series of divisions in the House. This has been an exceptionally good evidence session. I regret we have to conclude now. We'll not be able to hear from you again today. We have a series of questions we would have liked to ask you. We'll submit them to you if we may. You may be sending written evidence in any case. If you can address these questions, we would be grateful. And thank you very much for attending. I adjourn the committee until our session tomorrow. Thank you very much.
Committee Room 8, sound.